Morning. First case to come before the court this morning is Duer Construction Company versus Mid-American Construction and Fidelity of University of Akron. As you're aware, each party will have 15 minutes in which to present their case, but because we have so many cross people, it's my understanding you've all discussed this with each other and we've come up with an agreement that the appellants are going to share the 15 minutes, less rebuttal time.
Yes, Your Honor.
Okay, and that the appellant appellee cross appellant will have 15 minutes to do a construction. And then there'll be a rebuttal with the cross appellee. They're going to share the rebuttal time in American University of Akron Fidelity. So the only cross appellee is Fidelity. So is that how we're going to proceed? Is that everyone's understanding?
Yes, Your Honor. Yes, Your Honor.
Yes.
Okay. All right, that being the case, then the appellant, you'll have your 15, I don't know how many minutes you want for rebuttal, but you'll have that time. Let me know when you come up to the podium. I'm keeping track of the clock and keep you apprised of the passage of time. We are being visually and audibly recorded to be posted online, so please try to remain behind the podium as much as possible. We have ready your briefs, all of them, and we're ready to proceed when you are.
Thank you, Your Honor. May it please the court, I'm Tom Rosenberg. I represent Mid-American and Fidelity Deposit Company in Maryland. The court's representation is that the time commitments are correct. The University of Akron and I have agreed that we will reserve 5 minutes for rebuttal and split that time amongst ourselves, because that will be really the only time that Fidelity and Deposit gets an opportunity to argue the issue that the appellee or that Duer is seeking for a change in Ohio law to adopt bad faith. So we will take part of the time in the rebuttal to address that. The issues that we need to address right now involve Mid-American's appeal and the significant impact that the Court of Claims decision of October 1st, 2018 between the University of Akron and Mid-American have.
Why is it that you think we can consider the Court of Claims opinion?
The reason being, Your Honor, it is clearly supplemental authority filed here. The Court of Claims has made several decisions on it. Most important, the Court of Claims has determined that Mid-American Construction was improperly terminated for cause, and rather the University of Akron breached the contract with Mid-American, and under the contract documents, as the Court of Claims decision says, that termination for cause becomes a termination for convenience.
How do those findings make it supplemental authority? It's just supplemental proceedings, correct?
No, because you have another court. Issuing a decision that significantly impacts on the roles and responsibilities of the parties that are here before this court. What this court needs to do.
All right, excuse me a second before you tell us what we need to do.
I apologize.
We are reviewing a summary judgment, correct?
Yes, Your Honor.
We're reviewing de novo the record the trial court had before us. The trial court didn't have those findings before it.
You are correct, Your Honor, and what should occur, as a result, because we do have this very significant decision that's been issued by the Court of Claims, what needs to be done is this case needs to be remanded to the trial court of Summit County, so that the trial court of Summit County can consider the impact of the Court of Claims decision on the proceedings. It's got significant impact because of the conclusion that it made. Now, one note I have to bring to the court's attention, in fairness to everybody, is that yesterday the University of Akron filed an appeal of the Court of Claims decision to the 10th District. Which is why, again, one of the reasons why we are here before this court on numerous issues that aren't necessarily ready for adjudication. The trial court needs to consider the issues that were decided by the Court of Claims and its impact on this case. Why? Because one of the issues that exists in this case, and it's maybe getting into the secondary arguments, not the primary arguments, is the liability of the bonding company. And the liability of the bonding company is different when you have a situation here where there's been a termination for convenience as opposed to a termination for cause. That can give rise to defenses to the obligation to have made a payment here. The court is correct, though, in saying that, you know, if you look at it very narrowly, the question is that Mid-American is raising, is that it was premature for the court to grant summary judgment on Duer's claim. We established that there were material facts in dispute. The court below simply did not accept those material facts in dispute. The court below said that these were allegations of a set-off or recoupment that should have been raised as an affirmative defense, and the trial court was in error when it said that because in order to proceed on or recover on a breach of contract claim, they have to show the existence of a contract, performance, breach, and damages. And what Mid-American raised in the court below were defenses to the performance of the contract. Specifically, if you look at page 4 of the reply brief, and I think it's in the original brief too of Mid-American, we set forth an affidavit of Dan Trinetti of Mid-American that talks about defective and non-conforming work. We referenced the testimony of Jim Haskell at the university that talks about Duer's failure to perform. Now, whether that failure to perform was so substantial to go to why this project was delayed, you know, two years in completion or not is not the issue. The issue is whether or not Duer fully performed.
Counsel, you're talking about whether or not it was a material, is that right?
Correct, absolutely.
Isn't that material breach?
There-
So wouldn't that imply that there was a contract to start with, and doesn't that take us back to affirmative defenses?
It doesn't take us back to necessarily having to raise an affirmative defense of recoupment or set-off. What it does is it required the plaintiff below, Duer Construction, to establish the elements of a breach of contract claim. The key element for this discussion being performance, proper performance. And there was enough evidence submitted in response to their summary judgment motion when construing and applying the summary judgment standards that clearly indicated it was improper for the court to do what they did. In fact, I think the appellee talked about clear duty, and that wasn't the standard here. We know the standard on summary judgment, and there was enough in that record to do so. Going back for a minute, though, to the Court of Claims decision, because I think I know I only have probably a minute left. The Court of Claims decision sets forth a litany of failures to perform by the university. The failures to perform by the owner and its architect and construction manager that are in there significantly impact the obligations of Mid-American due and owing to Duer Construction. Regretfully, that's not before this court, and it wasn't before the trial court, which is why the best remedy, I think it's as Mr. 60B motion or something of that sort, but the best remedy is to look at that Court of Claims decision, remand this back to the trial court, tell the trial court to consider the impact of the decision and allow those proceedings to occur.
Counsel, as I'm sure my colleagues have read a lot.
Right, there's a lot
on this
in
case.
this.
I don't recall reading a motion to remand.
No, and the reason being is that this decision has just come out, and this decision has come out just in the last October 1st, and to consider the impact of it on this case.
November 1st.
You are correct, Your Honor. You are correct. The assumption is my 5 minutes are up, and I will.
Yeah.
My name is Jim Morgan. I'm here from the AG's office representing the University of Akron. As Judge Callahan noted, we're here on a motion for summary judgment. And the question is, are there material facts at issue? Well, we argued below that there were. The existence of the other case, which decided facts that determine the outcome of this case with respect to the university, resided exclusively in the Court of Claims. But the trial court in this case ignored the existence of that case in order to rule against the university in this particular case. If you look at the case, if you take the decision seriously, if you want to consider the Court of Claims decision seriously, it moots the claim against the university here.
I haven't read filed at this point at the trial court, but was there a motion made at the trial court to stay that pending?
To
court
stay the trial court,
Yes.
we asked the court in this case to stay it while that case was pending.
In this court, but what about in the trial court?
They would not, the trial court would not stay that case to wait on this one. The trial court was aware, I'll bring this to your attention, the trial court was aware, we presented the judgment from the trial court in the court of claims, but he didn't address it at all in the court of claims matter. It was completely ignored. And so the problem that we think is that our case is mooted now, because the court found the only damages that the Mid-American was entitled to in the court of claims case was the contract balance. How can we pay the contract balance to Mid-American and then pay it to Duer? It's the same money. They've exercised jurisdiction, and they told us the damages that Mid-American is entitled to are that same contract balance. So that moves this case from the university's perspective. I mean, the rest of the case would go forward from Duer's perspective. There's nothing that would prohibit them from proceeding on their appeal and executing on the judgments against Fidelity and against Mid-American.
Once again, I'm so sorry, I've been asking a lot of questions, you go ahead.
Just want to let you know you have just under 5 minutes total left, include that your rebuttal.
Okay.
Once again, your argument about mootness would entail us actually being able to consider the court of claims decision, correct?
We don't think you should, because we think that, because we filed the appeal, and we think we have a pretty good shot at winning on appeal, it will have issues that will be determinative of the university's liability with respect to this lien case. Because the court, as we argued in the briefs, I won't repeat them here, but as we argued in the briefs, the Supreme Court has already come out and said, if the prime contractor has no claim, then neither does anybody claiming through them. So subcontractors in the lien context cannot successfully claim, and that's one of the issues that's involved in that court of claims decision. And we'll reserve the rest for rebuttal. Thank you.
Good morning. I'm Todd Harpst, and I'm here for Duer Construction. Just so I'm clear on the time, I want to make sure I have 15 minutes total for all of our argument. I'd like to reserve 5 for rebuttal.
I don't know that there is rebuttal on your side.
Okay, then I'll just take my 15 or less and be done. How's that?
You're all going to, share the 5 minutes.
Okay, fair enough. That's why I asked, because I didn't want to be confused. And
Fidelity, University of Akron, and Mid-American all share 5 minutes.
okay, good enough. So I'm just going to start then with addressing the Court of Claims decision from Duer Construction's perspective. Duer was a subcontractor on this project. We worked under a contract with Mid-American. The university is the public owner, and they're subject to the public owner lien laws in Ohio. Judge Lanziger held that the university is liable to Duer under the public lien law for failing to pay Duer on their attested account lien. Now, what does effect did the Court of Claims have on that liability? None, from our standpoint. That doesn't change the university's liability here. If anything, it makes their liability even more undeniable, because the Court of Claims has ruled that the university owes $2.3 million to Mid-American. Under the lien law, it says that the university, as the public authority, is obligated to pay the subcontractors who filed claims the amount of the claim that's been assented to, which in this case it has, up to the balance due the contractor. The Court of Claims has settled that issue and has said the balance due the contractor is $2.3 million. Under the lien law, Duer's $97,922.20 should be safely in the university's escrow account, available to be dispersed to Duer now that that issue has been settled. So if anything, that case makes the university's liability undeniable, rather than meriting remand to Judge Lanziger. In other words, remanding it, in our view, won't change the outcome of the case.
Well, counsel, I'm going to start with the question that Judge Callahan started with your opposing counsel, and that is, how do we consider this Court of Claims decision?
We filed it as supplemental authority on behalf of Duer, and I believe Mid-American also filed it as supplemental authority.
I understand that.
Right, so I'll tell you what, we filed it as supplemental authority primarily because we felt the court should be aware of the decision. I don't believe it can have a collateral estoppel effect before this court because it's not part of the trial court record. So we didn't file it for that purpose.
That's what I'm getting at. because-
But the judge did make some rulings in that case, interpreting Ohio law, and made some legal analysis of the cases that apply in the context of this case. And for that reason, I suppose it could be considered to have some underlying precedent value. But we filed it primarily because we felt the Court of Claims, the Court of Appeals should be aware of that decision as part of the context of this case. But I would agree that it does not have a collateral estoppel effect because it's not part of the trial court record.
Well, and take it one step further, we really can't consider those findings, can we? The trial court didn't have those findings before her.
She did not. So yeah, I would agree with you. You probably can't consider them. My point simply is remanding it, though, doesn't change the outcome. So remanding it for Judge Lanziger to consider the effect of that decision on Duer's entitlement to be paid on the attested account won't change her summary judgment opinion. In other words, the findings of the Court of Claim, you can remand it, but it would be a moot point, is my point, that it doesn't change anything.
Well, the point is, I assume for you, representing Duer Construction, you just want paid.
We do, yes, Your Honor.
So I can't imagine you care who pays you.
We don't, that's right. And to that point, Fidelity has a judgment against it for the amount of Duer's claim that has not been appealed. And again, even if this court remands to consider the effect of the Court of Claims decision on the underlying liability between the university and Mid-American as to which one of them should pay us first, it doesn't change Fidelity's underlying liability to pay us now. The argument that Fidelity's liability can be no greater than Mid-American's, that would have been true in front of Judge Lanziger, and they made that argument. But she ruled against them and entered a judgment against them, and they did not appeal that. So I don't know how any change in Mid-American's liability affects Fidelity's liability because they're subject to final judgment that was not appealed. And that's what brings us to our bad faith argument. In this case, Duer's liability to be paid the $97,922.20 was never contested. Fidelity never disputed it. Mid-American assented to it when they failed to object to our lien, and under the lien law, that's a legally significant act of silence. They agreed that Duer was entitled to be paid. Fidelity sent a letter to the university that said pay Duer and the other subcontractors out of the contract funds. When they didn't, and they should have, but they didn't, that's what the payment bond is for. And so we're here also to ask the court, in this case, to look at the Suver decision from the Supreme Court of Ohio and say that decision provides authority for subcontractors like Duer to pursue bad faith claims against payment bond sureties like Fidelity when they don't pay claims in
You're
bad faith.
actually asking us to stretch that decision to apply to your facts, correct?
I wouldn't call it a stretch, Your Honor, but yes, we're asking the court to apply it to this context. Certainly, and we acknowledge the Suver case was a Fidelity bond in the context of a motor vehicle case. We acknowledge that. It's not on all fours with this case. But the reasoning and the principle of law that the court announced in Suver was that because of the special relationship between a surety and the obligee of that bond, it's identical to insurance, and for that reason, we're going to recognize a legal duty independent of the contract to pay in good faith. We believe that same authority applies here with equal force because everything lines up with that concept that the Supreme Court recognized was so valuable in Suver, which is Duer was wholly dependent on Fidelity to pay this claim. That bond was issued for Duer's protection against payment defaults by the contractor. And Duer doesn't have the ability to go out to the marketplace and find replacement performance when Fidelity defaults. They can't go enter a contract with a replacement surety or someone else to guarantee that payment after there's a default. So Duer is wholly dependent on Fidelity's good faith in investigating and paying these claims, which on this record, Fidelity did neither. And we think that this further merits the extension of Suver to our case because Ohio has a statute, Revised Code 153-54, that says that payment bonds are required on all public projects. And they are required for the benefit of the subcontractors and suppliers who perform the work that gets the public project done. We have to be able to depend on these sureties to pay these claims because subcontractors like Duer, we advance the money. We pay our employees payroll. We pay for the materials. We pay for all of the time and labor to build, in this case, the masonry part of Zook Hall. And when we don't get paid, we have nowhere else to go. That's what the bond is there for. And the legislature has felt that was important enough to make it a requirement of the revised code that these bonds be issued for the benefit of subcontractors. Now, the question always comes up is, aren't you just asking for us to find tort liability for breach of contract? And the answer is no, for two reasons. One, this is a liability that exists outside the bond contract itself, and it is a liability that's recognized by statute. And when we look at the Suver case, and we look where they came from, and we look at the other cases we've cited in our brief about other state Supreme Courts and intermediate appeals courts looking at the same issue, they have recognized Suver's value in adjudicating these commercial bond surety cases and construction contracts. So we believe, though not binding, those cases are very important for this court to consider when deciding the underlying legal issue. So with that, I'll conclude my argument unless the court has specific questions they'd like me to address. Thank you.
Yes.
Just under 4 minutes.
Performance, so we will split it equally, 2 minutes each between.
Okay, then I'm just gonna do this.
Excuse me?
Do this when you get to 2 minutes. Okay, not taking up any time.
And I am presenting on behalf of both Mid-America and Fidelity and Deposit here. I do agree with one thing that Duer said in its argument that assent to the lien constitutes an obligation on the university to pay. The university should have paid. That's not the focus of the rebuttal. The focus of the rebuttal has to be on Suver, Commercial Money Center, and toll testing, whether or not this court should, as the court has just said, stretch the law to establish a bad faith claim when the law does not support it. In fact,
Well, I said stretch with him, I'll say create with you. Apply to the narrow facts of this case.
well,
We can do that.
on page 2 and 3 of the reply brief, Duer says, no Ohio court has ever applied Suver to hold a public project payment bond surety accountable for bad faith to pay a lawful claim.
And that's why you come to the Court of Appeals,
Correct.
because you can say, we're gonna have a tort that says that it's bad faith for a surety on a payment bond on a public project, not to pay immediately or to act in bad faith.
Right, and no court has ever said.
I understand, but that's what I'm saying,
Right.
it doesn't really
Yes.
matter that no court has done that.
Right, no court, right, and
It's
that's,
always the first time.
there's, absolutely. But this court should not, this court should look at what's been instructed from the federal courts in Ohio on this. Commercial Money Center and toll test. Commercial Money Center, in our responsive brief, we included about 3 pages from Judge O'Malley's decision in which she very deliberately, looked at this and analyzed the issues and said that no, there was a difference between the Chapter 4509 bonds, the automobile liability bond, and a 153.54 construction bond, and it would be improper for this court to adopt the toll test.
If we, sorry for interrupting, but we're in such limited time. If we were to adopt this tort, what would be the ramifications of Fidelity still not paying, even though it has a judgment against it?
It would allow Duer to seek extra contractual damages. I mean, that's what it would do, because if you're.
Extra tort thing.
Right, extra, right. I apologize, yes, tort damages.
That's fine, I
It would allow them to obtain tort damages. And that's not something that
Because we're in
Ohio
that-
has ever permitted here.
But we're in that position now, Fidelity has a judgment against them, they did not appeal.
And in part, though, as even Duer says, I mean, the university had an obligation to pay that lien when it was assented to. Whether or not they have an obligation to make the payment isn't this narrow issue of applying Suver to the circumstance. The narrow issue here is whether or not on top of that, there is a bad faith claim. And Ohio has not adopted that. I'm out of time, but I would encourage the court to look very carefully at Judge Helmick's lengthy expose on this and Judge O'Malley's lengthy expose in the 2 cases. Thank you.
Thank you, Your Honor. a motion for summary judgment. Let's get back to the basics here. This is about what was the record in front of the court at the time the court made its decision with regard to the university. The court concluded that MAC's status, MAC being Mid-American Construction, their status didn't change as a result of the termination. That's a substantive finding that was the core of the trial in the Court of Claims. That's a material fact that was in dispute. It was acknowledged by Duer that the amount of the contract balance was in dispute. Duer has a burden to prove that there was available contract balance. There was no such proof. They made allegations, but they didn't provide any proof. The court relied, as did Duer, on the takeover agreement. And that said, the contractor in the original contract will now be F&D, Fidelity. It said the surety will subcontract to a completion contractor. Subcontract meaning they are now one step away from being a prime contractor. That same agreement said there will be no contractual relationship between the university and the completion contractor. How did Mid-American status not change under those terms? The court just ignored those terms when it rendered its decision. And that was a decision, that was evidence it had in front of it at the time. And that's problematic from the university's perspective, which is why we're asking for this court to reverse the decision of the court of trial court and remand the decision accordingly. Thank you.
Thank you both, all of you, for your presentations today. The court will take the matter under advisement and issue a written decision which will be mailed to both sides, actually all sides, as well as posted to our